my name is Jennifer Surmacz. I am the President and Chief Counsel of Posterity Legal Services. So in this video, we're going to talk about why wills lead to probate and why wills aren't enough. You know, there's a saying that your last will and testament is your last testimony of what you are willing or intending to happen. Where does testimony get heard? In probate court, okay? And so if all you have is a will, you're actually guaranteeing that your family is going to go through the probate court process after you pass. So just having a will is not enough. You need extra estate plan documents to make sure that probate court does not happen. So it doesn't matter if you think you made it ironclad, you can always have your children come up after the fact and say, well, mom said I could have the diamond ring. No, mom said I could have the diamond ring. And here we are in a contest in front of a judge. And the judge is going to sit there and listen to both sides of it and use his discretion to ultimately make a decision of who gets the diamond ring. So just because you're putting it down in your will of who you want to have what, that does not necessarily mean that's actually who's going to get it. When somebody passes away, there is this process called estate settlement that has to happen. Estate settlement is where we get your name off of your titled and signature property. So titled property is going to be like houses, cars. Signature property is going to be bank accounts, 401ks, IRAs. Dead people cannot own those things, and so we have to get your name off of those titled and signature property. That process, it's an administrative process, and it's called settlement of an estate. And when you do the settlement of estate, it can happen in one of two avenues, either the public avenue or the private avenue, okay? And when I say public, I mean government. That's what probate is. Probate is the government's plan for your estate to get your titled and signature off of those pieces of property. So when you initiate this probate court case, for instance, there is something called an automatic temporary injunction that goes on to all of your assets and freezes them so that the court then can see what assets you have, what debts you have, who needs to be paid off. That way we don't have money missing and all of that, you know, as we settle your estate. There's a lot of costs that are hidden that people don't understand. Half of the states do something called reasonable fees, and the other half actually have a set fee schedule. Who writes statutes? Lawyers, right? In our legislature. So who do you think gets paid first in these statutes? It'd be the lawyers, right? So when you look at the probate fee schedule, you see that your creditors are first in line, the lawyers are next in line, everybody else gets paid, and then at the end of the case, your children are the ones that get the leftovers. You know, when you have a jurisdiction that's like a reasonable jurisdiction, I can go to the court and I say, look, these are reasonable amount of funds that I'm asking for here. And like to an extent, that's true, okay? Because if I have to go to court every month because your kids are fighting about the diamond ring, I deserve to be paid for my time and effort for that. That would be reasonable, and the court agrees with me. Now on the other side, you have these fee schedules that are like set tables that says if the gross estate is from $0 to $100,000, then the attorney gets 3%. And then if it's 100 to 250, the attorney gets an additional 2.5%, and it goes on down. And if you're in that table type of jurisdiction, there's always a footnote that says these are minimums. Because once again, if I'm going to court for 2, 3, 5, 10 years, I deserve to be compensated for my time and effort. So those are the hidden costs that people don't realize, is that you have to pay the attorneys, you have to pay the executor. And even now with that, the attorney can also be the personal representative on the case. Therefore, I get paid twice if I'm probating your estate. So those are the large state jurisdiction specific probate codes. But then when you come down to the county, they also have their fee schedules too. Those local courthouses, you got your $250 filing fee, you've got a $30 publication cost, you got all these little, you know, that's what I call death by 1,000 paper cuts. So those are those hidden fees that are always going to come out of the estate first before your children receive anything. I think you need to go further than just a will. I think you need to make a private estate plan. That's the best way to keep everything private. Have your estate be settled privately, no court supervision, no publication, nothing published online. It's all done within the family. And it's done very quickly. I can usually get an estate plan settled within a year. It's not this long, drawn-out, red tape, money-sucking adventure. If you only have a will, you're putting your family through probate court. That's what's going to happen when you pass away.